My
Yes.
lord, I seek your lordship's indulgence in mentioning unlisted item.
Unlisted item?
Yes,
What?
it's
What
bail
is it?
application. We had filed it before the holiday. However, it's still not listed. If it may be listed just for issuance of notice for tomorrow. Bail application. 43.
BA.
Yes, my lord.
He's inside jail.
Yes, my lord.
Okay. Okay. Let the bail application be taken up. After
Obliged.
the part 1 matters.
My lord, if it can be listed tomorrow.
Oh, tomorrow you want?
Yes, my lord.
Okay, okay, fine. Tomorrow, yes. Tomorrow, yes, yes. I thought today you want it unlisted. No, tomorrow.
Yes, my lord. Obliged.
Tomorrow.
May I seek lordship indulgence in mentioning item number 2 of part 2, my lord.
Item number 2 of part 2.
Yes, my lord.
Wait one second.
Even though it is fixed for today, my lord, if it may be taken up after 2 weeks.
One
I've
second.
taken the consent of the respondent.
Wait. I'm yet to have my part 2 list. Part 2, item number 2.
Yes, my lord. RFA.
RFA. What do you want?
My lord, if it may be taken up after 2 weeks.
So on the prayer mail, you are for?
The
You are
respondent,
for?
my lord.
You are for the petitioner?
The petitioner.
Appellant?
Appellant, my lord.
And you are for the respondent?
Respondent number 7.
Okay. On the prayer made by both the parties, list this matter after 2 weeks.
No obliged, my lord.
For motion, item number 1.
Delwar Hussain Barmiya, this is for what?
Mayor,
Relaxation of bail?
yes, relaxation of bail, yes,
Okay.
Your Lordship.
What is the harshness?
The bail conditions are, number 1 is the accused petitioner shall execute a bail bond of rupees 3 lakhs.
Oh,
with two
like the other
sureties.
day.
Yes,
There was another matter where 3 lakhs was the bail bond and the surety was supposed to be a permanent resident with his own house.
yes,
Same is the case here.
yes.
Where are the conditions?
One surety shall be a permanent resident of his or living in his or her own house, while one surety shall be a permanent government servant, not below the rank of LTC.
Similar.
Yes, a similar order was passed on Tuesday by this court.
But
In-
in that case, the petitioners were drivers.
Yes,
Here, what are you? Dilwar Hussain and Jiarul Islam? What way you are involved in what offense?
Section
Have you annexed the FIR?
21C and 23C of NDNPS. The petitioners are belong to the state of Assam, Kachar district. 2 petitioners in this matter. They were arrested on 31/7/2024.
Same case, that was
Yes.
co-driver, these are co-accused.
Yes,
Oh, acha, these are co-accused.
yes.
And those are the appellants? They are also drivers.
Yes. A driver and a
On
co-driver.
non-furnishing
Yes.
of grounds of arrest, they were released on bail.
Yes.
What do you say? 3
Lordship,
lakhs and permanent resident.
Lordship, notice may be issued at this stage, and I'll accept notice in behalf of the respondents. Because I have not received any petition from the
Acha, you have not
respondent.
got the copies.
Lordship, yes.
Otherwise, you are the only respondent here. We are appearing for the sole respondent.
Sole
right?
respondent, Lordship. Then
Directorate
I'll
of-
accept notice on behalf of the sole respondent today itself. So I have to go through the files also, Lordship.
Otherwise, if we know, we could have disposed it off by lessening the conditions. If he is not, see, the order was of 14/8/2025.
Maybe, Lordship, but I'm
You have to
I'm
go-
handicapped without the files, Lordship.
Okay, fine. Okay, this is an application filed under section 442, read with section 484 and 528 of BNSS 2023 for modification / relaxation of bail bond and sureties. Oh, no, relaxation of conditions such as bail bond and sureties imposed upon the petitioners by the court of judge, special court, NDNPS Act 1985, Aizawl Judicial District, Aizawl, by its order dated 14/8/2025. The two conditions that the petitioners have sought for relaxation are: one, the petitioners were directed to execute a bail bond of rupees 3 lakhs, and the other one is that the sureties were directed to be were two in numbers, okay. Sureties were directed to be two in numbers, one being a permanent resident of Aizawl living in his or her owned house, and the other surety is directed to be a permanent government servant not below the rank of LVC. Issue notice or heard Mr.
Lalpian Fela Chongthu.
Lalpian Phela Chongtu.
Yes.
Mr. Lalpian Phela Chongtu for the petitioners, and Mr. Johnny N. Tauchuang
Lordship, yes.
for the respondent. The special public prosecutor, right?
Yes, Your
The
Lordship.
special public prosecutor for Directorate of Revenue Intelligence. Issue notice. Since Mr. Tauchuang appears for the sole respondent, no formal notice is required to be served upon him. However, Mr. Chongtu will serve copies upon Mr. J. Tauchuang within the course of the day. List the matter. When do you want? Next week?
Next week, 16.
Tuesday.
List the
Tuesday.
matter on
Tuesday.
16th.
Tuesday, 14.
Tuesday. Okay, 14th. 14th will do, Mr. Johnny?
Yes, Lordship.
14th will, 14th October.
Oblige your lordship.
Item number 2.
Yes.
Your Lordship, this is
It
a
has come up for the first time.
first time, my lord. A petition filed for.
Let the notice be issued today.
My lord, my lord.
Okay. Okay, heard Mr.
C.
Joram
Joram
Chana,
Chana.
right?
C.
C. Joram Chana.
My lord.
For the petitioners. This is an application. Under Article 226 of the Constitution of India for issuance of writ in the nature of mandamus or any other writ against the petitioners
No, against
or
the
against the
respondent.
respondents. The instant case relates to an issue. Oh yes, I also heard Mr.
Samuel Malad.
Also heard Mr. Jairam Sangpoi the learned CGC for
I'm
responding.
appearing, no, my lord. Mr. Samuel.
Mr. Samuel, right? I get confused sometimes.
It's okay, my
Mr.
lord.
Samuel Vallan Riata Changte for respondent number 2 to 4.
2, 3 and 4, my lord.
Yes.
NHIDCL.
Okay, for respondent number 2, 3 and 4. Notice was already issued or what?
My lord, this is
my
a
lord,
motion stage, my lord.
Now it's motion stage.
Acha, okay.
Since they are now having standing council, my lord, so he's reflected.
Wait. Okay. There are other respondents?
My lord, yes.
6.
Number 1 is the central government in which there is CGC, and we have certain copy to.
Zairang Sangku is
Zairang
not there,
Sangku-
she could have appeared otherwise. Okay.
She might be on lake in the other court now.
Other courts. And then 2,
2,
3 and 4
is
Mr.
NHIDCL.
Samuel, you are
Yes, my
appearing?
lord.
Is the
I'll be
standing council.
representing the same.
My lord.
And 5,
5 is the state, my lord. We have already.
Venetiani's name is shown.
Yes, your lord.
Only 6 notice will go.
My lord.
Kala.
Kala. Okay. Yes, the instant case relates to an issue where the petitioners, who were the owners of the 2 plots of land, right? They were the
My lord.
owners of 2 plots of land, were acquired by the respondents.
Actually, my lord, not acquired.
Not acquired,
acquired.
right?
Yeah,
That
my lord.
were-
They have been damaged.
Purportedly acquired
Yeah, yes, has to be, yes.
because they were dumping, right?
Dumping soil.
So purportedly acquired by the respondent authorities, inasmuch as the respondent number 2 to 4 had dumped art spoils
My-
and soil
My lord.
on the said land.
Without
The
paying any,
petitioners had
without
made-
paying any compensation. Yes.
Yes, those have not come at all. The petitioners have made representations for compensations, and it is also stated that the respondents had done spot verification and have duly admitted of dumping soil, but yet neither the land was acquired under the law nor any compensation was given.
My lord.
The petitioners, having no other alternative, had approached this court by filing this petition. Mr. Samuel Changte appears for respondent number 2 to 4. Miss Linda, you cannot appear, right? Or you can appear for 5, I think. Or she can appear, right?
Yes, my
Mr.
lord. Since it's state,
State.
Venetiani is there, but then you can appear, this is state.
she can accept
Miss
notice, my
Linda
lord.
M. Farbal, L. Farbal, appears for respondent number 5.
Eh, no, she-
Anybody from the central government here sitting? No one, right?
She's on leg, my lord.
Acha, anybody apart from Zairang Sangkui?
No,
Anybody?
my lord.
You can call her or what? If you can call someone,
Yeah, now move.
okay, not required. She will otherwise come. Then issue notice to respondent number 6. The petitioner to take steps for issuance of notice upon respondent number 6 by registered post with AD or with usual process,
My,
not
so
required.
Actually, my lord, the DC Kala is only a short distance from here, my lord. If
Dusty.
possible, my lord, you can also take Dusty, my lord.
Oh. And
If
if
possible.
required, even by dusty mode,
My lord.
returnable by 3 weeks. List this matter after 3 weeks.
Obliged, your lord.
Obliged, my lord.
For admission, item number 3.
Yes,
May I
Mr.
please,
Malhotra.
I just received the affidavit filed by the private respondents yesterday.
58,
Yes,
some
9 to
9
58.
to 58.
Yes.
Acha, they were given number of chances
Yes.
and then,
Yes, my lord.
I received
Sorry for that.
okay, you need to have, you need some time to go through
and reply. Yeah,
and reply.
yeah. 3 weeks.
Heard Mr. A.R. Malhotra, learned counsel appearing for the petitioners, and Mr.
Bilal Ramenga.
B. Lalra Menga,
Yes, madam.
learned counsel appearing for respondent number 9 to 58.
Yes.
And what about 1 to 9?
State.
1 to 6. Miss Linda L. Farbal appears for respondent number? 1 to 6. 1 to 6 and 8. Okay. What about 7? 7 is left out.
1 to 8, my lord. Stage is 1
It will
to
be
8.
1 to 8 here.
1 to 8. But otherwise, in the last order also it is written 1 to 6 and 8.
Yes, that's one.
Just check 7.
Yes, 7 is the ZM Zoram Medical College.
The
This is
directors, ZMC,
Autonomous institution.
no
So,
more.
note.
No.
Notice,
Your Worship, in fact, she can appear, Your Worship.
government advocate can appear.
It's no more a society.
What do I write? 1 to 8?
All right, my lord, but we have filed affidavit on behalf of this 1 to 6 and 8 only, so. I
She
think,
can take instructions, Your
get
Worship.
instructions
okay.
after that.
No, 1 to 6 and 8, huh? It is noticed that the petition, that the affidavit has been filed by respondent number 9 to 58 on 8, right?
8, my lord.
On 8th of October, that is yesterday, 2025. And copy has been served upon copy has been served upon the petitioner. Mr. A.R. Malhotra as such prays that he may be given some time to go through the same as well as to file an affidavit in reply to the same. Prayer is allowed. Further, Ms. Linda L. Farbal is directed to take instruction as to whether she can appear for respondent number 7 as well. List this matter after 2 weeks,
3 weeks.
3 weeks.
I'm
List this matter after 3 weeks.
Item number 4.
Your Lordship, I'm appearing on behalf of my senior aides, Lalmal Somi, who could not appear today due to some personal difficulties. So I'm praying if the matter can be taken up tomorrow.
Next week, Monday, Tuesday?
Yes,
Okay.
Your Lordship. Oblige, Your Lordship.
Okay. So your name, wait, let the order be passed. Okay. Let the order be passed, then you can leave. We are not in a hurry. Heard miss, your name please?
Generally, Lalmang Isangi.
So and so, appearing for?
Aides, Lalmal Somi.
Acha. H. Lalman Saumi.
Yes, Your
Appearing for H. Lalman Saumi, learned counsel appearing for the petitioner. And also heard, your Linda, you are there in this
Yes, my
matter?
lord, respondent 3, I think.
Okay, and Miss Linda L. Farbal for respondent number 3. The learned counsel appearing for the petitioner prays that the conducting counsel has some personal difficulty and has prayed for some time. Prayer is allowed. List this matter on 14th of October.
Item number 5.
Please, Your Lordship.
Yes.
My Lord, in this case, in the last court date, despite service of notice, the private respondent number 2 had failed to make appearance. So
no
opportunity was
representation.
given to the respondent number 2 to enter appearance during the
Today
period.
also no representation on behalf of respondent number 2?
I
No,
don't
my
think
lord.
so, Your Lordship.
We can proceed ex parte,
My Lord.
or we will wait for some more time.
It would be inconsequential because this case is basically between the appellant versus the present respondent number 1.
1.
Yes,
Or,
who is
you-
represented.
Or you want some legal aid counsel to be there?
It may not be necessary because the claim, in this case, Your Lordship, we have filed an appeal against an order whereby amendment was allowed after a period of 3 years. And we had already submitted our written statement. I am the defendant.
Amendment to what?
Amendment of the plaint.
Plaint, okay.
After a period of 3 years, after written statement was submitted, and we had made our defense. So we are filing this appeal against that particular order. So it would.
You
it
are
would-
against the amendment allowed?
I am against the amendment. I am the defendant. My learned friend is the plaintiff.
Who is respondent number 2 otherwise?
Defendant number 2
Defendant number 2
In the trial court.
in the trial court.
in the trial court. So what should be done is let a legal aid counsel be there. Later on, one should not come and say, I was not heard. So
Very well, my
he
lord.
has not appeared.
It may be appropriate,
We
my
will
lord.
not wait,
Yes.
but like a legal aid council, next week this matter can be heard, right?
Yes.
Otherwise, the issue is very small. It's only on that point.
Okay. Only on amendment.
Yes, Your Lordship.
Okay, fine then. Right, heard Mr.
Lalfa Koma.
Lal Fakoma. You were there in that contempt matter, right?
Yes, Your Lordship. I was not keeping well that particular
Oh,
day.
it's okay.
My
I
junior
have
was there.
delivered the judgment.
Yes, Your Lordship. I
Saying
saw the
that
judgment.
blueprint area and these are two separate things.
I saw the judgment, Your Lordship.
I'm sure they will go to Supreme Court. Yes, and then I've heard Ms. Lal Fakoma for the petitioners. And
Appellant, Your Lordship.
for the appellants. And
Mr. B. Lalramenga, my lord.
B.
Lalramenga.
Lalramenga for the respondents.
Number 1.
For respondent number 1. It is noticed from the earlier orders that although notice has been served upon respondent number 2, but there is no representation on his behalf. As such, in the interest of justice, this court deems it fit that a legal aid counsel may be appointed to defend respondent number 2 in the instant proceedings. Any legal aid counsel here?
The registry has a list, Your Lordship.
Acha. Otherwise, I can also appoint from here.
That can be done as well.
Yeah, but you are there, Mr. Jordan? You are legal aid or amicus?
Legal aid.
Legal aid. Okay, Mr. Jordan Romingtonga is appointed as a legal aid counsel to defend respondent number 2. The petitioner is as such directed to serve the necessary documents to Mr. Jordan Romingtonga within a course of within 2 days.
Within 2 days, madam.
Within 2 days, a matter to be listed on next week.
After a week, my lord?
After a week.
After
Matter
a
to be listed after a week on a date to be fixed by the registry.
Yes.
Deeply obliged.
Much obliged.
Item number 6.
Your Lordship, in this matter,
Ms. Zarang
Counsel-
Sankui and Ms. Vanishami, you were not there, a matter was called, I think item number 2 I'm talking of.
Yes, my lord.
Yeah,
I'm sorry.
Yes, it's
I was
okay.
on lag, my
In
lord.
case of Vanishami, Ms. Linda has accepted the notice, but Zairang Sankui, I'll just write her name, huh? You write?
For
Ms. Zairang
respondent number
Sankui
one.
for respondent number 1,
Oblige.
in item number 2. Yes, here.
my
I
lord,
think
my lord, in the present matter, Mr. P.D. Nair, he requested me to make a mention on his behalf. Due to personal difficulties, he could not come.
his
Counsel for
PD
the
Nair is for the appellants.
For the petitioner, my lord,
For the
item
petitioner.
6. Yes. So if it could be kindly taken up again on 10th of November, my lord, as per his request.
10th of October,
10th of November.
November, yes.
Yes, my lord.
10th of November, okay. Heard, your name please, Mr.
Bill Ramenga, my lord.
B. Lalra Menga, yeah, I forget.
It's all right.
For the petitioners who submits that Mr. P.D. Nair, who was supposed to conduct this, the instant case, has some personal difficulty and has made a prayer for taking up the matter on 10th of November. The prayer is not objected to by Ms. Zairang Sankui and Ms. Linda Faubal, appearing for the central government and state government respectively. And you were supposed to file your affidavits also.
Yes, my lord. In In the the meantime, we we'll be have filing. not received yet, so another 2 weeks' time, by the time the case is listed, hopefully we'll be filing.
And it is also directed that the learned counsel appearing for the central government as well as the state government may file their respective affidavits before the said date. List this matter on 10th of November.
Highly obliged, my lord.
Item number 7, 8, 9, and 10.
I'll take 7.
Lordship, these
Ah.
matters may kindly come up on 30th, my lord,
30th of October.
October, my lord. 30th.
Yes, Mr. Malhotra and Mr. Jordan. This is for cancellation of bail.
My lord.
Don't want to do it today.
No, my lord, I did not receive instruction for today.
Okay, right.
My lords, I just have one request, my lords. I'm sorry, my lords, that is the other matter in item 14. It's similar cancellation. There, my lords, we are yet to file a wakalatnama and reply, my lords. Because it's a
Okay,
new...
let me pass order here
Yes, yes.
then. Okay, right, Mr. for the petitioner. Mr. C. Joram Chana. Heard Mr. C. Joram Chana for the petitioners. And Mr. A.R. Malhotra for the respond. Mr. A.R. Malhotra, you're for respond number? Two. Two in which items?
Item 8 and 9.
Acha, 7 you write. Mr. Jordan Roming Tonga for respondent number 2. A prayer is made by Mr. C. Joram Chana, Learned Counsel for the petitioner, that the matter may be taken up on 30th of October. Prayer is allowed. The said prayer is not objected to by the Learned Counsel appearing for the respondents. And you also write Miss Linda for respondent number 1. The matter to be listed again on 30th of October. 8 you write. Mr. C. Zoram Sharma same, but Mr. A.R. Malhotra for respondent number 2. 9 also, you are there, Mr.
Yes.
Malhotra. And 10 you write Jordan again. Rest will be the same. Yes.
And 14, madam. 14 is similar, madam.
Oh yes, 14. 14, what happened? 14, it's a new matter.
My lords, it was filed much later.
Acha, acha. You will be appearing for respond number 2.
Yes, my lords.
Otherwise, I think steps were not taken by them.
My lords, we've received now.
Acha, acha, okay. Give me 14. Item number file of item number 14. Item number 14, you write. Heard Mr. C. Joram Chama. Although in the last order, dated 4/9/2025, it is reflected that the Learned Counsel for the petitioner had not taken steps for service of notice upon respond number 2. However, when the matter is called up today, it is seen that steps have been taken, and Mr. Jordan Roming Tonga has submitted that he will be filing Wakalat Nama on behalf of respondent number 2. And Ms. Linda N. Faubel appears for respondent number 1. There is a further prayer made by Mr. C. Joram Chama that the matter may be taken up on 30th of October.
Obliged.
Along with the other matters.
My lord.
Along with, you give the numbers, along with criminal petition number 13 of 2024. Prayer is allowed. List this matter on 30th of October.
Obliged.
Item 11.
My lord, I am for the newly implemented respondent number 6.
That
I
no
may be,
affidavit.
yes, I
Okay,
may be
file
given
affidavit.
3 weeks time for obtaining instruction and for filing affidavit.
Obtaining instruction to
Yes.
file.
My lord, for obtaining instruction,
To file affidavit.
yes, to file affidavit.
Acha. And R6 has also not filed. You are
State-
R6.
I'm for R6.
Oh, acha, okay. So heard Mr. Your name
Stephen
is?
Albotseya, on behalf of City Council.
Okay. For the petitioners and Ms. Zairang Sangkui, Learned Counsel for the respondent number 6. Ms. Zairang Sangkui makes a prayer that she may be allowed some time to get instruction as to whether she would file an affidavit in the instant case. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry.
Oblige.
Item number 12.
Item number? Item number? 12.
May it please your lordship, I'm appearing on behalf of the state respondents. Your lordship, if
I think you are yet to file your affidavit.
yes, your lordship, if 2 weeks time may be granted, your lordship, because I have spoken with the I've spoken with the Land Revenue Department, and it seems, your lordship, unfortunately they had misplaced the copy of the petition, so I've had to give the
Okay,
copy
I'll
again,
give
your
you some
lordship.
time to file your
Yes, your lordship.
Heard Ms.
Niropari.
Opa for the petitioners
Yes, my lord.
and Ms. Lalran Pui, right?
Yes, your lordship.
Lalran Pui for the state
Your lordship,
respondent.
Lal Nunlu, your lordship.
Lal
Louis.
Nun Louis
Yes, Your Lordship.
for the state respondents, right?
Yes, Your Lordship.
What about other respondents?
All the state
Your Lordship,
respondents,
there are
my
no
lord.
private respondents.
Acha. Miss Lal Nun Louis, it makes a prayer that she may be allowed some time to file the affidavit as the department had not got the copies, right?
Yes, Your Lordship, they informed me that they had not received it, so I'll have to send it again. Yes, Your
As
Lordship.
she was informed that the department had not received the copies of the instant petition. Prayer is allowed. List this matter after 3 weeks.
Yes, my lord.
On a date
Much
to be
obliged,
fixed by
Your
the registrar.
Obliged.
Item number 13.
May it please your lordship, I am here for the petitioner, my lord, and we had recently received the affidavit in opposition by the respondents. And my lord, we are seeking for another 3 weeks' time to file our reply in the said additional.
Mr. Malhotra, you are for respond number 1 to 5?
No, I'm for respondent 6.
Acha, respond number 6.
Yes.
1 to 5 was state respondent?
University, Mizoram University.
MZU.
Mm-hmm.
Mizoram University.
Acha, okay. So counters have been filed by all the
All
respondents?
respondents.
Okay, so right, heard Miss?
Miss Rosie,
Okay, for the petitioners and Mr. A.R. Malhotra for respond number 6 and Miss
Rudar Watfeli.
for respond number 1 to 5?
1 to 5.
1 to 5. Miss so-and-so appearing for the petitioners have prayed for some time to file her affidavit in reply to the counter affidavit filed by respondent number 1 to 6. Prayer is allowed. List this matter after 2 weeks.
3 weeks, my lord.
3 weeks.
3 weeks? Okay. After 3 weeks on a date to be fixed by the registrar.
Obliged.
Item number 15.
Mr. L. Porter, yes.
Yes, Your Lordship, I'm appearing on behalf of the state respondents. Your Lordship, this matter was referred for mediation, however, it has been referred back to the court. So, Your Lordship, we will-
Mediation failed.
Yes, Your Lordship. So, Your Lordship, if I may be allowed 3 weeks' time to file my affidavit in opposition, Your Lordship.
Okay. What do you say, Mr. Porter?
For respondent number 1.
You are for respond number
Yes,
1?
my lord.
CGC. And Mr. Samuel?
We've already filed.
Oh, you have filed your affidavit? Yes, CGC has filed affidavit?
Not yet filed, my lord.
Not yet. Okay. Heard Mr. L. Pauto for the petitioners and Ms. Zairong Sangpui, the learned CGC for respond number 1.
Yes, my lord.
Respond number 1 and Nalnun Pui.
Lalun Louis, yes, Your Lordship,
Yes.
for
respondent
respondent
number?
number 6.
For respond number
6, Your Lordship.
6. 6. And Samuel L. Changte for respond number 2, 3 and 4. Ms. Lalun Louis.
Yes, Your Lordship.
I mean, those words are difficult for us to pronounce.
Your Lordship.
And Louis, for the state respondent, has prayed that she may be allowed some time to file her affidavit. And similar prayer is also made by Ms. Jairong Sangpui. However, it is noticed that the respondent number 2 to 4 has filed affidavit as stated by Mr. Samuel L. Changte. List is prayer is allowed for the respondents to file their affidavit, respective affidavits. List this matter after 2 weeks.
Yes, Your Lordship. Much
After
obliged,
two-
Your Lordship. Yes, Your Lordship, 2 weeks will do, Your Lordship. Much
After 2
obliged.
weeks on a date
In the
to be
meantime, my
fixed.
lord, allow me to rejoin the affidavit to the affidavit filed by the respondent number 2 to 4.
Okay. And it is also further directed that Mr. L. Pauto is permitted to file his affidavit in reply to the affidavit filed by the respondent number 2 to 4.
My lord,
List this matter after 2 weeks.
obliged.
Part 2 hearing list, item number 3.
Item number 3. Yes, Mr. Jordan?
My lords, I appear for the appellant, my lords. My lords, if I may just pass on one small note.
Okay. This is an RFA.
My lords, the facts are very short. My lords, I would not take more than 40 minutes at max. My lords, the facts are very simple.
Yes.
And my learned friend would not object to these facts, my lords. My lords, I've said there, my lords, the plaintiff's case before the trial court was, my lords, for declaration that the defendant, today the appellant, is liable to pay this amount, my lords.
Okay.
54 odd lakhs. My lords, I'll just stop here, my lords. What today the appellant is what, my lords? My lords, I am a contractor, grade A contractor. I get contracts from, my lords,
You were for the plaintiff.
I was for the defendant, my lords.
Acha, acha.
The suit has been decreed in their favor.
Okay, okay.
So, my lords,
Suit was for a declaration that the defendant was supposed to pay a particular amount to was supposed to pay a particular amount to the plaintiff. Okay.
Yes. Now, my lords, I am a contractor. I had received two contracts from the PWD department. My lords, they are at the third column. Your lordships would see two contracts. One was Girder Bridge, Aizol district.
1 second. So you were a contractor, you
Yes.
were allotted 2 works.
Yes.
Okay. Okay.
These are the two works, my lords. Girder Bridge and Sazek Bridge. My lords, the plaintiff's case was that there was an oral agreement, nothing in written, with me, and whereby he stated that, my lords, he had worked as a subcontractor, while I said he had worked as a mere manager to manage the affairs of the works, my lords. This was it. Now, my lords, if we come to the fifth column, Girder Bridge and Sazek Bridge, this is the case before the trial court, my lords. Insofar as the Girder Bridge, it was alleged that the agreement between plaintiff and defendant that works would be executed in an amount of rupees 1 crore 50 lakhs. This is what they sought to prove, my lords.
Okay.
I am saying, my lords, it is not 150. It was around, my lords, 1 crore, around 1 crore, my lord. Insofar as the other work, my lords, the agreement was that, as per their case, it was that the works would be executed at the rate of 150 per kilo of iron used there, of steel used. Suit. Insofar as the other contract, I'm taking your lordships one by one. The plaintiff had claimed, my lords, that 3 lakhs was paid to him. Again, an admitted fact, no doubt about it, my lords. But there was a further amount of 6 odd lakhs still due to him. Now, my lords, our only case is that there was no evidence, my lords, to prove their case before the learned trial court.
Okay.
Now, my lords,
Because everything was on oral.
everything was in oral, my lords. The findings given by the trial court on the different issues set was, my lords, whether firstly, issue number 2 was, my lords, that issue number 2 was, my lords,
There will be some witnesses.
my lords, they had got 2 witnesses, apart from the plaintiff also deposing. But, my lords, there is nothing substantial to claim at least the amount to be payable to him.
They have claimed 54 lakhs,
Yes,
58,000.
together.
465.
Yes.
Okay. Based on the statement of the witnesses.
Statement of the witnesses, and my lords, they had annexed WhatsApp chats to show that there was some relationship going on between the two of us.
He was your manager.
He was my manager. You call him, my lord, subcontractor also, let us say. But he has to prove that that amount was due and payable. It cannot be done orally, my lords. Even if it was done orally, some witnesses had to make a categorical direct statement on that fact. That was not. I'll show your lordships. But before I go there, my lords, I'll just take your lordships through the issues which was set up by the trial court, my lords. If your lordships would have the paper book.
Yes.
At page 72, my lords. And I'll take your lordships through the pleadings also, but I'll just, so that the issues are, my lords, forthcoming, my lords.
72.
Yes, my lords. Para 15
Yes.
at the bottom. So your lordships here, hence considering the pleading of both the parties, the following issues are framed on so and so. Whether the suit is maintainable. My lords, we're not pressing anything on this today. Whether the plaintiff is a subcontractor under the defendant or just a work manager. Number 3, if the plaintiff is a subcontractor under the defendant, whether the work of subcontract was prematurely terminated. And fourth, my lords, whether the plaintiff is entitled to the relief claimed, if so, to what extent. Now, my lords, I'll just take your lordships to the findings, which is starts from the next page at page 73. Insofar as issue number 2, which is whether the plaintiff was a mere manager or a subcontractor.
Yes.
The trial court, my lords, at para 21 starts discussing, it is actually a reproduction of the pleadings made before the trial court. But the effective part, I would like to take your lordship straight to page 76 at para 27.
Yes. Okay.
My lords. In his cross-examination, the defendant stated in point number 3 that he does not remember the exact time when he started to engage the plaintiff.
Defendant is you.
Me, my lords, appellant. Started to engage the plaintiff and also do not remember the time when their engagement terminated. In point number 6, the defendant admitted the suggestion that he and the plaintiff, by way of telephone call, discuss about construction work of Azol Lay before they physically met each other for the said work. The defendant further admits the suggestion in point number 7 that he never used the term manager to the plaintiff at the time when construction of Azol Lay was about to carry on. There is also no written communication made with the plaintiff with the terms manager. While defendant witness number 2 stated in point number 5 of her
Who is
cross-examination.
DW number 2?
My lords, DW number 2 is the wife of the defendant,
Your wife.
my wife. Stated in point number 5 of her cross-examination that the plaintiff was given a sum of money by way of cash, bank transfer and check by the defendant, and also personally handed over the said sum of money to the plaintiff in some occasion, and she mostly transferred by way of bank transfer as far as she remembers. In point number 7 and 8, she has further stated that the plaintiff was paid 10% of the work completed by him as his salary, and she does not know as to whether the said money was redistributed to non-meso workers by the plaintiff or not, my lords. Because, my lords, most of these steel workers, my lords, being a specialized skill, a lot of workers are coming from outside, my lords. So, my lords, in para 27, what is clear is that there is no written agreement, no written communication.
Things are so vague.
Very
What money,
Yes, my lords.
how much was the amount? Only 10% of the work as his salary.
Yes, my lords. Basically, my lords, when works are given to contractors, the contractors, your lordships knows that the 10% margin is the profit which is established, my lords. So, my lords, that is what they had seemingly promised. And it comes within the amount we have already paid, my lords. Para 28, your lordships, I'll carry on. on careful consideration of available evidences for both the parties, it is not disputed that the plaintiff had executed the construction works of girder bridge known as Aizol Lay at Upper Khatla, Aizol, and Sazek Bridge strengthening works at Rajiv Nagar, to which the defendant was the contractor for both construction works, and there is no agreement between the parties.
It's a subtle position.
Yes. Para 29. As per the evidence of the plaintiff, he had executed the construction work as subcontractor under the defendant, which is verbally agreed upon by the parties through telephone calls. This was his case, my lords. Corroborating this, the defendant admitted the suggestion in point number 6 of his cross-examination that he and the plaintiff, by way of telephone call, discussed about construction work of Aizol Lay before they were physically met each other.
So within second one, I'll just go through this line.
Yes.
Corroborating this, defendant admitted the suggestion of his cross-examination that he and the plaintiff, by way of telephone call, discussed about construction work. It's a subtle position that he worked under you.
Correct, my lords.
He worked.
Yes,
He got money.
he got money.
Only that some part he did not get, that is what his case is.
Correct, my lords.
Okay. So they were physically met each other.
Yes,
Okay.
my lords. After they had the telephone call, my lords. Further, the defendant admitted in point number 7 that he never used the term manager to the plaintiff at the time when construction work of Aizol Lay was about to carry on. This is in the considered opinion of the court, of this court, that the plaintiff was not engaged as a manager.
Acha.
Just because, my lords, it did not come out in the evidence that during our talks we did not use the term.
He is a he is a subcontractor.
This is what his case was. my lords. Para 30.
In fact, you did not physically meet each other.
My lords, we met after having the talks that please work for me as a manager and manage the affairs of these works. There we met. My lords, may I carry on?
Yeah.
Although the defendant stated in point number 3 of his cross-examination that he does not remember the exact time when he started to engage the plaintiff and also does not remember the time when their engagement was terminated, the plaintiff evidences is that the defendant offered the said construction to him, work to him on 18th March 2018 through phone call, and after accepting the offer for the defendant, the plaintiff started the construction work without delay in full swing on 11th April 2018, since there was extreme pressure from the public as well as the concerned department, and they had carried on their work in day and night. On the basis of Exhibit P9, my lords, these are the checks. He just wanted to show that payments were made to him. That we don't deny. Was issued by the defendant in favor of the plaintiff for withdrawal of rupees 30 lakhs on 8th April 2018, which is after the telephonic conversation of the plaintiff and the defendant, and 3 days prior to the execution of the construction work by the plaintiff. Further, on the basis of exhibits P10, 11 and 12, these are all payments, my lords, your lordships will see. It is evident that the defendant issued check number so-and-so for so-and-so, and my lords, if we skip to the last amount, on the basis of exhibits as stated above, a number of checks were issued in large amount of money for execution of the construction works. In the meantime, there is no evidence on records for both the parties regarding the salary of the plaintiff in daily or monthly basis as a manager under the contractor, that is the defendant. This is, in the considered opinion of this court, another indication that the plaintiff was not engaged as a manager. My lords, here we have to say that when the court itself says there is no evidence on record to prove this or that.
They had presumed.
Presumed.
Because checks were given not in the terms of salary.
Yes.
So they have presumed cannot be a manager.
Correct, my lords. Now, my lords, these are the findings. At para 33, it concludes that therefore, on the basis of available evidences on record with facts and circumstances of the case, as stated above, this court is of the considered opinion that the plaintiff was not engaged as a work manager, but he was working as a subcontractor.
Okay, what is that Supreme Court decision about?
My lords, here, if I may read, my lords, State versus Ananda Prasad. Once the plaintiff agreed to execute the work at a particular rate and got the work done to the satisfaction of the defendant, it is not open for defendant or to to vary the rate to the prejudice of the, my lords, this is not applicable in our case, my lords. Now, my lords, this is the first issue. We are saying that, my lords, this presumption, my lords, it has to be based on some evidence, my lords. How can, my lords, the learned court just presume, my lords, based on averments? These are all based on averments, my lords. So, my lords, this is our crux submissions insofar as issue number 2. Issue number 3, my lords. Now, there is a agreement that the respondent, the plaintiff would work for the defendant, no doubt, my lords. But the issue framed was whether it was prematurely terminated. Now, my lords, it is an oral agreement. If at all there was supposed to be this case of premature termination, where are the terms, my lords? It had to be proved. And, my lords, the findings starts from, my lords, page 79,
Yes.
para 37. On the basis of evidences adduced by both the parties, it is evident that after verbal agreement, the plaintiff started the construction of Azol Bridge on 11th April 2018, and as there was extreme pressure from public and concerned department, the work was carried on in day and night. That as per the evidences of the plaintiff, when 99.90% of the work was completed, I just want to stop your lordships here. This percentage of work completion, my lords, we have not admitted, first of all. Second of all, there is no evidence to show that such a work was completed during his time of employment with us. I'll carry on there, my lords. Was completed, the defendant without proper reason asked him to leave the construction of Azol Bridge work and offered another work, that is Sazek Bridge strengthening work at Rajiv Nagar. This is the second work contract. It is further evident that when the construction of Azol Bridge was completed, that is the first work, there are 5 head mistries along with a number of daily laborers. And Mr. Zakir Hussain, who was one of the 5 mistries employed in the bridge construction and was an alcoholic, often caused trouble.
He's not the same Zakir Hussain, right?
No, no, I was apprehending that question may come
Okay.
to his fellow workers, and also used to misbehave to the plaintiff family.
Achha, wait, just let me go through this. It is further evident that construction of Azol Bridge, that when the construction was completed, there are 5 head mistries, along with a number of daily laborers, was one of the 5 mistries employed in bridge construction and often caused trouble to his fellow workers. Okay. Misbehaved with the plaintiff's
Yes, my lords.
family.
And hence Zakir was finally terminated for the work of Azol Bridge. My lords, there was a main mystery who was into the steel fabrication of the bridge. There was some, my lords, animosity between the plaintiff and this head mystery. He's our worker, actually. So, my lords, therefore, he has come into the picture somehow. But I don't think it would indicate anything so far as this issue is concerned. Para 38, after termination of Zakir Hussain, the defendant offered the Sazek Bridge strengthening work, which is the second one, to the plaintiff, and after verbal agreement, the plaintiff executed the Sazek Bridge strengthening work. But when 90% of the work was completed, again, my lords, this is just based on a verdict. Yes, my lords, disputed. Severe floods struck them and waited for certain time. However, the defendant, without proper reason, again ordered the plaintiff to leave the bridge strengthening work. Therefore, the evidence of the defendant that the plaintiff became dishonest and incapable to continue the work, an immediate cause arose when the plaintiff had ill-treated one of the 5 witnesses, Mr. Zakir Hussain, is ruled out on the ground that after termination of the said Zakir Hussain and completion of 99.90% of Azol lay, the defendant had offered another work, that is Sazek Bridge strengthening works to the plaintiff, and the present issue is decided in a positive and in favor of the plaintiff. My lords, all I'm saying is...
What was the present issue that he... Oh yes, prematurely terminated. Okay.
My lords, oral agreement. This, my lords, cannot, it's not sustainable, my lords. My lords, the main issue now I'm coming to, my lords. And your lordships, I'll just read the entire, because this is the main effective consequential review. Issue number 4. whether the plaintiff is entitled to the reliefs claimed. If so, to what extent? For determination of the present issue, the plaintiff stated that on 18th March 2018, the defendant contacted the plaintiff and offered the said construction work through telephone call and offered rupees 1 crore 40 lakhs only for the construction work. That the plaintiff asked the defendant to increase a bit more, and thereafter the defendant offered another rupees 10 lakhs only, which would make the total sum of rupees 1 crore 50 lakhs, which is accepted by the plaintiff. My lords, this was the plaintiff's case. Never admitted by us, my lords. Para 41 onwards, that as per the exhibits P9, 10, 11 and 12, the total amount... Checks. The total amount paid, total amount of money paid by the defendant to the plaintiff for construction of girder bridge, that is Aizawl Lane, was given in check in 4 installments amounting to 90 lakhs. And another rupees 11 lakh 50,000 was given through direct transfer to his bank account. And the total amount paid to the plaintiff is 1 crore 1 lakh 50,000. So, my lords, there are 4 checks and 1 transaction through banking channel.
So 49 lakhs was less.
Yes, as per him. With regards to the Sazek Bridge strengthening work, the plaintiff further adduced that as per the verbal agreement between the parties, he had executed the work at the rate of 150 per kilo and completed 90% of the work when the severe flood struck them, to which the defendant paid rupees 3 lakhs by way of check, and the remaining balance is 6 lakhs 8,456. Para 43. Although the defendant denied almost all the plaintiff case, he has corroborated the total amount of payment he has made and stated in para number 7 of his evidences that with the BHE money, my lords, BHE is Blue Hill Engineers. It is my proprietorship firm.
Okay.
Yes, ma'am.
Name is?
Blue Hill Engineers.
Oh, Blue Hill, yes.
With the BHE's money being spent by the plaintiff, the value of all the work completed by the plaintiff was calculated to be rupees, this is our case, my lords, 96 lakhs 39,774. Because, my lords, 1 ton of work done, because it is a steel bridge,
So this is for strengthening. Sajek.
Yes.
It is in respect of Sajek.
No, my lords, this is in respect of the first Aizawl Lake.
Aizawl
Girder
Lake.
Bridge.
Okay.
So, my lords, per ton we are calculating at 1,04,997. And I'm just stating here, my lords, this is just for just something extra, my lords, that this calculation was also not given by the plaintiff in his pleadings. We had, my lords, justified the amount, stating that per ton we are calculating at 1,04,997. Since
So
he
you are
had,
disputing that 1 crore 50 lakhs.
oh, yes, my lords, we are disputing the 48 lakhs 50,000 remaining. My lords, if I may continue, and that he has already, so my lords, work completed to be calculated at rupees 96 lakhs, and that he has already given the plaintiff exceedingly an amount of rupees 1 crore 1 lakh 50,000. Because, my lords, 96 we are saying that is the proper amount. This is the work which he had managed, but we had given him an extra amount which comes up to 1 crore 1 lakh 50,000. Difference is about, my lords, 5 lakhs.
No one will pay extra amount.
My lords, that is, my lords, something else. But, my lords, this part is also not clearly given in the defendant's statement.
Acha.
An amount of rupees 1 crore 1 lakh 50,000 in installments, and out of which 10% of the amount of work completed by the plaintiff would be his salary.
And out of which 10% of the amount of work completed would be his salary.
That
Okay.
means, my lords, around 10 lakhs would be his profit. In point number 26 of his cross-examination, the defendant denied the suggestion that while contacting the plaintiff, he proposed to the work for rupees 1 crore 40 lakhs, and also denied the suggestion that while contacting the plaintiff, he proposed to the work for rupees 1 crore 40 lakhs, and also denied the suggestion that he accepted to give a bonus of rupees 10 lakhs. In point number 27, my lords, this is a wrong finding, I'll show your lordships from the record. In point number 27, he has liabilities amounting to rupees 48.5 lakhs to the plaintiff for Azol Lay and rupees 6 lakhs 8,465 for Sussex Bridge. My lords, the trial court is saying that in your own deposition, you have admitted that it's due and liable.
But that is not the case.
Yes, my lords, I'll show. Can I just show, my lords?
In point number 27,
Yes.
he has liabilities amounting to almost like, acha,
It's
okay.
framed in such a
This
way
is
that...
almost giving his case,
Yes,
I mean.
yes, my lords. My lords, can I just show one page? Page 58, my lords.
58,
Yes.
point number 27.
Point number
I
27.
deny the
I
suggestion.
deny that I have liabilities.
That was not properly put here.
Yes, my lords. So, I
He denied his liabilities, he could have written that.
correct, my lords. But the opposite has come. Nonetheless, my lords, I'll carry on with the findings. In the case of Teshi Shelley versus Tayyum Ete decided on so-and-so, it was held in deciding a civil suit. It is preponderance of probability of the case of both contesting parties that should be taken into consideration. Principle of strict liability that is proved beyond reasonable doubt is not required to be applied in deciding a civil suit. This is not, my lords, objected to. 45. Therefore, on the basis of the above discussion, with findings in the foregoing paragraphs, this court is of the considered opinion that both parties made verbal agreement for execution of girder bridge, that is, for a sum of rupees 1 crore 50 lakhs, only out of which the defendant had paid rupees so-and-so, 1 crore 1 lakh 50,000 only, with the remaining balance of rupees 48 lakhs 50,000. Further, that there is also agreement for Sussex Bridge strengthening work at the rate of rupees 150 per kilo, in which the defendant paid rupees 3 lakhs only, with the remaining balance of 6 crore 8 lakhs so-and-so.
6 lakhs,
Yes, my
8,000.
lords. So together, 48 plus 6, my lords, it is that total 54. So, my lords, the concluding 46 is decided in
Yes.
favor of the plaintiff. Today, my lords, our case is just this much, that where is the evidence, when did the burden of proof ever shift upon me, my lords? The case was not made out by the plaintiff. The plaintiff's suit had to stand on its own legs, my lords, insofar as the evidence. Now, my lords, I'll just take your lordships straight away to the evidences which were adduced. Now, my lords, the plain starts at page 1. Page 1, my lords. And I'll just take your lordships through certain paras of this suit. My lords, if your lordships may come to page 3.
Yes.
My lords, at page 3, if your lordships comes at the first paragraph, continuing paragraph from the 10th line, even though.
Yes, even though.
Even though there was no written contract made between the parties. However, existence of contract between the parties is very clear from the foregoing averments as well as enclosures to this plaint. Now, my lords, what has he enclosed? It's right there, the foregoing paragraphs. Photocopies of screenshot from WhatsApp conversation, marked as annexure so-and-so, respectively. Photographs showing construction works. This is all, my lords. We are not denying about the oral agreement. At para 5, that the work was quite expensive, needed huge expenditures right from the beginning. And defendant had, now this part is very important, my lords. Defendant had paid certain bills, cost of the said work to the plaintiff in installment. Because, my lords, as we proceed a bit further, he says that I had actually made loss, the plaintiff. But, my lords, our case was that for the materials, for the labors, everything was borne by us, the expenditure. It is he who profited. However, my lords, I'll just continue. The total sum paid to the plaintiff for the said construction was rupees 1 crore 1 lakh 50,000, leaving a balance of 48 lakhs 50,000. Payment for a sum of rupees 90 lakhs only was given in check as shown below. My lords, these are the 4 checks. However, another sum which totaled rupees 11 lakhs 50,000 was paid to the plaintiff, herein through direct transfer to the bank account of plaintiff by the defendants. So, my lords, what has been given is the photocopies of the checks and also of the banking, online banking transaction. This is his evidence so far, my lords. And I'm sorry, my lords, can I just take your lordships through what all were also annexed to the plaint?
Photocopies of these checks, and the other one is also given, right?
Yes, the online banking transaction.
Online banking.
Yes.
Okay. That is not annexed or what?
My lords, let me take your lordships.
There are only 4 checks.
4 checks. 1, 2, 3, 4. My lords, I'll just pinpoint that page.
A. After that, there is nothing.
I'm sorry, my lords, it's not here. Yes, my lords.
22A, 22. Or it's not at all legible.
Yes, my lords, the true type, I think it's better copies are given. I'm sorry, my lords. Only the detail is given in the record, but not the photograph.
Okay.
But we are not denying, my lords. We admit. So, my lords, coming back to the plaint, I just, for the sake of completeness, if I may take your lordships from page 1.
Yes.
Para 1 at below, what has been annexed as evidence is photocopy of certificate of registration. That, my lords, he is a proprietor of this MP Steel Fabrication, the plaintiff. Thereafter, my lords, at para 2, at the next page, is the photocopies of completion certificate dated so and so, issued by BGM Consortium. These are his past works, my lords. Doesn't relate to us.
Yes.
So, my lords, these are annexes 2 and 3 respectively. So, my lords, I just wanted to show your lordships what else was there. So, my lords, coming back to para 6 at page 4. My lords, there is very important statement made, my lords, that when 99.90% of the work was completed, the defendant, without proper reason, asked the plaintiff to leave the construction work and offered another work, that is Sazek Strengthening Bridge at Rajiv Nagar. Since the plaintiff was in good faith, he simply accepted the said offer and left construction of Girder Bridge at Upper Khatla. So, my lords, how can you claim even premature termination or some wrongful loss to him? He had done it out of his own volition. An offer was given, he left in good faith, my lords. And for that, my lords, he had given a voice recording of the conversation. But, my lords, even though, my lords, a picture of the compact disc is annexed to the paper book, I only have to say that there is nothing substantial in this to show that, my lords, the issue should be in his favor at all. Therefore,
Where
my
is
lords,
Annexure 7, show me?
yes, my lords, Annexure 7 is at page 21, my lords.
There has to be a CD, I think it is.
Yes, my lords, page 21, at least we have received the, I believe the trial court record is also there, my lords.
It's okay.
Yes.
Then?
So, my lords, this is the CD. Thereafter, my lords, the further amount of 3 lakhs which was paid via check, para 7.
7 years.
I'll just read, my lords. Defendant again verbally agreed to do Sazek Bridge strengthening work at Rajiv Nagar. It was verbally agreed by parties that the said construction work was to be executed by the plaintiff with a rate of 150 per kilo. Plaintiff had promptly started construction, but when 90% of the work was completed, severe flood struck them to finish the work and waited for certain time. The defendant had paid rupees 3 lakhs by way of check bearing so and so. However, the defendant, without proper reason, again asked the plaintiff to leave the said strengthening work, making a balance of rupees 6 lakhs 8,465. What was again annexed was photocopy of the check and the photocopy of the works at Rajiv Nagar, my lords.
Okay.
Then, my lords, at para 8, from the facts and circumstances, it is clear defendant without proper reasons terminated the verbal contract made with the plaintiff in 2 occasions as given above. Plaintiff suffering in both pecuniary and non-pecuniary losses, severely affecting his business. As such, defendant must be in duty bound to pay the agreed sum. The total sum due to defendant is rupees so and so. My lords, if at all there was any loss, pecuniary, my lords, it had to be, my lords, some evidence had to be adduced. That even after several requests and demands at para 9, defendant did not pay heed and failed to compensate the loss suffered by the plaintiff. However, the defendant informed the plaintiff that he engaged him as work manager in such construction, denying their contract as given above. It is pertinent to mention herein that the plaintiff, who is well-reputed establishment, could in no way be engaged as a mere work manager for such single construction, as the plaintiff is in fact busy enough in his own establishment. But having heard the offer, he accepted the same in good faith as stated above. It is to be mentioned that if the offer was a mere manager, the plaintiff would certainly decline such offer from the beginning. The plaintiff, through lawyers, served a legal notice dated so and so to the defendant, noticing him to make a payment of rupees so and so within 1 week of receipt of the notice. However, despite duly receipt of the notice, defendant failed to pay the said amount.
Okay.
So, my lords, I will not take your lordships through these further averments. And my lords, the reliefs claimed are at page 6. This is just, my lords, for sake of completeness that I am showing. Beyond that, my lords, I just want to show the oral evidence adduced by the plaintiff. My lords, your lordships would have page 38 of the paper book.
This is plaintiff witness number 1.
Yes, my lords. This is the respondent today. I, Lalnunthara, so and so, my lords, I'll just quickly go through it. I'm a bona fide citizen. I am the plaintiff in the instant suit. I am the proprietor of MP Steel Fabrication with well reputation for a period about 15
So he
years.
is the plaintiff.
Yes, plaintiff. My lords. I have very good experience in fabrication, steelworks, and experience in construction of major structure at different places in Mizoram and outside states. I have earned several outstanding performances in such work. In the year 2007-8, I worked with BGM Consortium, having its main office at Calcutta. I worked for all iron structure and other steelworks at Aizol, and completion certificate dated showing my performance was issued. Again in 2015-16, I worked all the iron steel structure, roofing, chain, link fencing, SS Rail Works in construction sports stadium at Zoklang Sampai under Messrs Balaji Developers, having its main office at Ghaziabad, UP, for which completion certificate dated 8/1/17 was also issued with outstanding credit. That the defendant had a work for construction of girder bridge at Upper Khatla, in which I was engaged to execute the construction work. Now, my lords, something has just entered my mind which I sought to portray, is that the plaintiff admits that the contract from the PW department came to me. If at all there was some sort of subcontract, he could have, my lords, adduced some form of agreement, and that too with the acknowledgement of the PW department. There he would make his case.
Yes.
Para 6, I'll carry on, my lords. Defendant, when he was allotted said construction contract, contacted several steel fabrications as he intended to engage them for carrying out the construction and more particularly steelworks. On 18 March 2018, defendant offered the construction work to me through phone call and requested me to undertake the work, and offered me a sum of rupees 1 crore 40 lakhs only for the said construction. In response, I told the defendant that rupees 1 crore 40 lakhs would be cheap for such huge construction and asked him to increase a bit more. Thereafter, defendant offered another rupees 10 lakhs only for erection of work, which would make a total sum of rupees 1 crore 50 lakhs. Thereafter, I accepted the offer and agreed to do the construction of the said work for a total sum of 1 crore 50.
It's a construction of bridge, right?
Yes.
And what he said is, he offered me for carrying out the construction,
Yes.
and more particularly steel work.
Yes.
So he was engaged with the steel work.
Correct. That is correct, my lords. He himself says, I'm a steel fabricator, because, my lords, the entire bridge is made out of steel.
So in that case, he cannot be a subcontractor. he was assigned for the steel work.
Yes,
He is an employee. of
correct,
the-
my lords.
He is engaged by the
Yes.
defendant.
My lords, I am only saying this, that you may call him subcontractor also.
Mm.
But how is that money due and payable? That is the main question, my lords.
Then?
Para 7, that I started construction without delay in full swing on 11th April 2018. As there was extreme pressure from public as well as concerned department, PWD, the construction was carried on in day and night, and hence labor cost was also extremely higher than usual. In short, I did my level best efforts for speedy completion of the work in day and night. Para 8, that the work was quite expensive, needed huge expenditure right from the beginning, and the defendant had paid certain bill costs of the said work to me in installments. However, the total sum paid to me for the said construction of girder bridge, was rupees 1,01,50,000, leaving a balance of rupees so and so. Payment of rupees 90 lakhs given in check is shown as below. However, another sum which total 11 lakhs 50 was paid to me through direct transfer. That when 99.90% of the work was completed, defendant without proper reason asked me to leave the construction work and offered another work, that is Sazek Bridge. My lords, I will not go beyond this because it is a reproduction of his own averments made in the
Yes.
thing, my lords. Now, my
Let me
lords,
see other witness.
my lords, other witness is at page 48. Lordship says it. My lords, Anwar Hussain is apparently an employee of the plaintiff. I am a bona fide citizen. I used to work in MP Steel Fabrication Khatla under the proprietor of Mr. Lalnun Thara, who is the plaintiff, from 2014. I have been working in both Sazek Bridge and also Aizol Leh Bridge, Upper Khatla Aizol. That Mr. Lalnun Thara employed me for the construction of Aizol Leh, and we also received our salary from him, and there is no pending salary. That during construction of Aizol Leh, we worked under the supervision of Mr. Lalnun Thara. However, when MP Steel Fabrication was terminated from said construction of Aizol Leh, I also gave up the work of Aizol Leh, and as far as my knowledge is concerned, the total number of persons left the said construction was around 20% when MP Steel Fabrication left the site. That when we left the site, we almost completed the work, and at least we finished 99.90% of the total works. I also worked under Mr. Lalnun Thara for construction of Sazek strengthening bridge, which is a second work site. After completion of around 90% of the work, we could not continue to work due to flood, and we left the work. That the plaintiff herein has never worked as manager under Blue Hill Engineering. This is his limited. But my lords, he makes a very important statement in his cross, which is at the next page. I hope, my lords, I'm not taking it too fast, my lords.
No, it's okay.
Yes, my lords. Page 50, para 3. It is a fact that I do not know whether there was an agreement between the plaintiff Lalnun Thara and the defendant. 4. It is a fact that the construction of Aizol Leh and Sazek Street were Dr. Lal Khamana's work. This is the appellant today, the defendant's, who is the proprietor of Blue Hill Engineering. So, my lords, even his own thing says that this is the works of the.
Wait, strengthening where doctor, that is you.
That is I.
Dr. Lalthar's work.
Yes.
Definitely it was your work.
Correct.
Then his statement would be relevant to the extent that it was terminated.
My
Right.
lords.
But then he said, however, MP Steel Fabrication was terminated from the said construction. They have finished their work almost.
My lords.
So where is the question of termination?
Correct, my lords. My lords, even if you terminate, I can legally terminate. They have to prove that it was premature or not, and loss was conceived,
Yes.
my lords.
Then?
My lords, there was another plaintiff witness who has made similar. He's another employee of the plaintiff at page 51. He makes similar, my lords. And at
Same statements?
Same statement, similar. Should I go through my notes?
No, not required.
Not required, my notes. At page 53, he
Cross?
also makes the same admission
okay.
at para 4. It is a fact that the construction of Aizole was Dr. Lalta Mona's work. Insofar as the other one, my lords, he does not say.
Yes.
Yes.
He also said when the agreement was undertaken, they did not know.
Yes, my
I
lords.
do not
at
know
para
what
2.
kind of agreement
Yes.
was made between plaintiff and so and so.
Yes. So, my lords, this
He
is
says that according to my knowledge and own understanding, Lalnun Thara had
Yes.
taken the work from so and so as subcontractor.
Subcontractor.
He of course says.
yes.
Then
Now, my lords, these are the evidence, oral evidence before the court. My lords, my evidence is also there, but without taking your lordships through that, I'm just taking your lordships lastly to my written statement, which is at page 29. Page 29.
yes, page 29. That is WS to the plaint.
Yes,
Yes.
my lords, that I'm taking your lordships through the relevant paras. Para 4, answering defendant denies content strongly objects all the averments made by the plaint. Because, my lords, I just wanted to, your lordships, know that everything was denied. My lords, para 5, but sub para 4 at page 30, I just want to show what our case was, my lords. That the defendant needed a considerable number of different field assistants, which may be called as managers or interpreters. In brackets, it's written Vaitrong Letu Tur, which means, my lords, somebody who would translate the language. Or interpreter, construction equipments and workers to execute the work. So, to interpret to the workers also, my lords, and gather the construction equipments. At sub para 5, that the defendant did not need any subcontractor to do his work, but he needed a manager who would collect some construction materials, seeking workers from outside of Mizoram and to interpret with the workers. At sub para 7, that the plaintiff was not capable of being employed as a subcontractor because a subcontractor has to have proper knowledge regarding the work without any supervision of engineers or other experts. Because, my lords, during the entire time, I was there overlooking. His own photograph at the work site would show me in the middle of the picture. Or else, my lords, if I had subcontracted, what business would I have there apart from, my lords,
You
dealing?
would not have come at all.
Would not come. My lords, sub para 8 and 9, that eventually it was decided that BHE would employ the plaintiff as a manager and he would be given training and guidance to supervise the work. It was also decided that BHE would give money in advance to the plaintiff for the costs of expenditures periodically after every particular work is done. It would be the duty of the plaintiff to spend the sum for buying materials and paying the salaries of laborers. That it was offered that after the work was completed, 10% of the estimated amount considered as contractor profit of the work completed by the plaintiff would be his share. Now, my lords, on merits at page 31, this is the justification for payment of such an amount. Para 3, that the contents of para 4 are false, strongly objected, that the work was allotted to the defendant and the plaintiff was merely employed to look after the construction. And from 11 April 2018 onwards, the construction began and it was offered and agreed between the parties upon the following terms and figures. A, my lords, total steel requirement for the bridge construction was 141.90 tons. This includes, my lords, materials, supporting materials, scaffolding, etc. And then, my lords, insofar as there are at A1, steel requirement was around these many kgs, so and so. The total amount of everything, my lords, apart from steel, gusset plates and all that, my lords, it comes to around 100 157 ton. And the
Gazette
addition,
plates are not steel.
my lords,
Gazette plates are not steel.
my lords, I'm sorry, these are. What I was meaning to say was that, my lords, the 141.90 ton at para 3A is, my lords, being bifurcated as to where so much amount of steel is going. So the scaffolding supports 41.74 ton. This is, my lords, which needed special expertise anyway. So this was the remaining 41 tons which they claim, but which we have justified in our written statement. So, my lords, at para B, sub-para B, the quoted rate of work was calculated in terms of ton, and rupees 1,04,997 per ton, and the whole work was estimated at 144 ton, which is worth about 1 crore 48 lakhs 99,000 so and so. That the plaintiff was employed and asked by BHE to manage and complete the work only with his collected laborers and workers up to 100.157 ton for the construction of the bridge only by using all the materials provided by the BHE, and the remaining 41.74 ton was the supporting materials belonging exclusively to the BHE. So, my lords, insofar as the steel bridge,
BHE is?
the appellant, defendant, my lords, he had done 100 ton, an amount of 100.157 ton for the construction of the bridge.
Yeah.
Therefore, my lords, that payment of 1 crore 1,50,000.
And at 41.74 ton
Yes.
was supporting materials belonging to your company.
He left, my lords. He left by then. I completed that part
Acha.
by myself.
So he is entitled for only 100.157
Correct.
ton.
Yes. And my lords, if your lordship sees that again, this would be, I'm sorry, my lords, the calculation of the amount has not been given. But my lords, the actual amount, if your lordships calculates it at 1,04,997 per ton into 100.157 ton, the amount comes to around 1 crore 5 lakhs 15,184. So, my lords, I have given even more that.
But
If-
you have given 1 crore 1 lakh.
I'm sorry, 1 crore 1 lakh 50,000. That is true, my lords. Now, my lords, if your lordships comes to the, with regards to the second works, my lords. With regards to the second works, which is, we've said it at para 6 at page 33. That the BHE had offered the plaintiff to manage and do the work of Sajak Bridge strengthening work at Rajiv Nagar only if the plaintiff was willing to accept the rate of work offered by the BHE, that is rupees 80 per kilo of iron. This is our rate. That the plaintiff did not make any acceptance of the rate of BHE. However, the plaintiff simply started the work without making any proper acceptance to the BHE's rate. That the BHE provided the materials for the work and it was the job of the plaintiff to manage and do the work. My lords, if we come a little below of the same paragraph, which starts with however. However, the BHE carefully calculated the work which was already undertaken and finished by the plaintiff, including his small contributions of materials, and that it was estimated to be rupees 3 lakhs. That the BHE for ends of justice paid the estimated amount of rupees 3 lakhs to the plaintiff without delay, and thereafter it is strongly asserted that BHE has no amount due to the plaintiff. So, my lords, this was our case. Unfortunately, my lords, we had not annexed anything to our written statement.
So, as far as the second work is concerned, you had given your rate
Yes.
80 rupees per kg.
Kilo. Yes.
And by calculating it, it comes to 3 lakhs.
Yes.
And you have paid 3 lakhs.
Yes.
You say that nothing more is required.
Yes. My lords, with regard to the first, your lordships had asked a very pertinent question. I was lost in the calculation. Your Lordship says then a limited amount of money is still payable. Because I had said that if you calculate 100.1, if Your Lordships comes at para C of para 3, that the plaintiff was employed and asked by the BHE to manage and complete the works only with his collected laborers and workers up to 100.157 ton.
Yes.
My lords, this was our agreement as per us. And the amount comes up to 1 crore 5 lakhs 15,000.
1 crore 5 lakhs?
15,000.
50,000.
15,000, my lords.
15.
Yes. 15,184. My lords, I'll just quickly cross-check if Your Lordships permits me, my lords. I'm sorry, my lords. 1 crore 5 lakhs 16,000.
16,000?
184.
180 rupees.
This was what he was supposed to do. But at para F of sub-para 3 only, the next page, we've said, my lords, that with the BHE's money, the defendant's money being spent by the plaintiff, the value of all the work completed by the plaintiff was calculated to be rupees 96 lakhs 39,774. That is 91.81 ton. So, my lords, we are saying he completed this much. 91.81 ton
Of steel, right?
of steel.
And then he was supposed to complete the work with 100.157 ton.
Out of that, he's completed this much.
He has completed with 91.81 ton.
Done.
And then he was made to leave his work,
Correct.
right? So that will come to a lesser amount.
Yes,
So
yes.
1 lakh, 1 crore, 1 lakh.
Yes, we've paid that 1 crore 1 lakh 50.
Just see this calculation, how much it comes. Oh, 96,000, right?
Yes, yes, ma'am.
96,039.
And
Had
if
already paid
the plaintiff
in
exceeds-
installments.
Yes. So, my lords, an additional amount was given. The difference is 5 lakhs 10,645. This is the excess amount which we had given because of our own miscalculation as per instructions, my lords. So, my lords, unless Your Lordships, if I can clarify any point, if I may take Your Lordships through just the judgments and what our main point is.
It's okay, as far as I can understand.
Yes.
And what about the other witnesses on your behalf?
On my behalf, my lords, if I may take Your Lordships to page 54. This is the proprietor, the defendant himself. Page 54.
This one, okay, I've seen.
Page 54, my lords. Lal Samwana.
That one, okay, then. This is cross-examination. Anything important from cross-examination?
No, my lords, we are only saying that at para 15 at page 58, we will not deny the facts. At para 15 at page 58, my lords, I admit the suggestion that I paid the expenditures to the plaintiff. And the plaintiff was the one who again paid salary of other laborers who were engaged through him. This is all, my lords, I wanted to say.
So your case is that, as far as the first construction is concerned,
Yes,
you have paid.
we have paid,
Wait.
my lord.
As far as the first construction
Yes.
of the bridge,
Yes. My lords, Your Lordships may kindly refer.
of the bridge, yes, that I have. So according to you, that ton of steel will
Yes.
go into that work, right?
Yes, yes, my lords.
So you have paid 1 crore 1 lakh,
Yes,
more than the amount actually that he deserves
correct.
because of miscalculations.
Yes,
You have paid it in installments.
yes,
And so 5 lakhs you have paid more
yes, my lords.
because you made them work only with that ton
Yes,
of steel.
yes, yes.
And as far as the second is concerned, there was flood and all, and then you had paid the amount.
3 lakhs, we had paid 3 lakhs.
You have paid 3 lakhs.
For that, they're claiming, my lord, 6 lakhs.
Huh.
6 odd lakhs.
How come you have that 3 lakhs thing? Where did you show it from?
My
Show
lords,
me from?
My lords, if Your Lordships would come to
You have shown that 3 lakhs.
Yes, my lords. Page 33 at para 6 of our written statement.
Yes, okay. You had your own rate,
My lords.
80 rupees per kg.
Yes.
And by calculating that, that 3 lakh is paid, and they had also not, complained about the rate.
Yes,
They
my
did
lords.
not say anything.
They started
They
construct-
continued with the work.
Yes, yes, my lords.
And so you had paid 3 lakhs as
Yes,
it
ma'am.
is. And so no extra payment. Okay, I can understand your case.
My lords, can I, my lords, take your lordships through certain judgments? Though the law is...
Yes, 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 yes.
My lords, after maybe referring to 3 out of the 6 judgments I've cited,
Okay.
I
Renu
may
Sri
conclude.
Lahkar.
versus Pradeep Kumar Lakar. My lords, if I may read, what therefore follows from the above authorities is that when both parties adduce evidence in support of their respective issues and the entire evidence relating to the facts in issues are before the court, burden of proof loses its importance and the question of burden of proof becomes merely academic. That is if, my lords, evidence is adduced. What is important to note is that evidence must be adduced in respect of the issues involved. Mere examining some witness by both parties or adducing some evidence is not relevant to prove the real issue in controversy, or when such evidence adduced by the parties are not sufficient to arrive at a satisfactory conclusion without further evidence. Relevancy of burden of proof does not disappear. Therefore, when each party adduces evidence to prove and disprove the facts in issue, then only the importance of burden of proof disappears. There is no gainsaying that the initial burden is on the shoulder of the plaintiff who knocks the door of the court for a decree or relief in his favor, asserting certain facts, being the sole basis of the claim, be it negative or positive, to prove such facts. Unless the plaintiff discharges his burden, he cannot succeed in the suit, despite weakness of the defense case. Apparently, in the case at hand, the plaintiff brought the suit for declaration that the alleged deed of partition was forged. Therefore, necessarily, initial burden was on the plaintiff to prove the plea of forgery. If the plaintiff adduces some evidence in discharge of his burden, the onus may stand shifted to the defendant to rebut such evidence. Therefore, unless evidence is brought on record enabling the court to come to a conclusion on the facts in issue, the question of burden of proof remains relevant. Because, my lords, all we say is, insofar as the issue number 4 of the liability of 54 lakhs, where is the evidence? Nothing, my lords. You have proved that we had an agreement, oral agreement. That we don't deny also. But only issue number 4, my lords. My lords, I'll just take your lordships to one more judgment. And we may refer to the, my lords, at the next page in the 3rd column, Adi Veppa versus Bhimappa. My lords, the facts in that case was again partition suit.
So initial burden is on the plaintiff to prove his case and allocate evidence in support thereof. Okay.
Yes, my lords. So, my lords, it's on the same proposition, so I would not go further, my lords. Conclude with that.
These are your.
My lords, this is my lord.
Okay. Yes, Mr.
May it please your Lordship. Lordship, perusal of the whole submissions of my land friend, as well as from perusal of the appeal, memo of appeal, I may say that this issue is with a limited question as to whether the oral evidence adduced by the plaintiff is sufficient or not. So for that, your Lordship, my learned friend had already come across the pleadings and some evidences, so I'm not going in again in that particular part. So, your Lordship, first of all, I'd like to say that I have 3 witnesses, including me. Like that, the appellant also has 3 witnesses, including himself. So, my other 2 witnesses are the one who actually involved in particular construction, Lordship. Both construction. One involved in both construction, the last witness involved in one of the 2 constructions, Lordship. However, Lordship, the appellant's witnesses, one of the witnesses is his wife. And during the interrogation, during the communication, she didn't marry the appellant. It means it took place before they got married. And
What, it took place before they got married?
yes, the communication took place before they got married, Lordship. Communication between the parties, Lordship, regarding the construction. And after they got married, Lordship, she somehow managed the payment of the money to the respondent here in Lordship. However, Lordship, she did not involve at all in the construction, Lordship. Means she has no personal knowledge, Lordship. And another witness is an employee of the BHE, an employee of the appellant, till date. But, Your Lordship, he did not have any personal knowledge about the construction. I'll come to that, Your Lordship.
It's okay
So,
now.
Your Lordship, my submissions would be on that point, Your Lordship. My witnesses are relevant witnesses. However, the appellant's witnesses are nothing but to substantiate the arguments, Your Lordship.
It's okay, witnesses may be not important, but then you have to stand on your own foot.
Lordship.
You have to show your own evidence.
Yes, exactly,
Show
Your
me the
Lordship.
evidence.
For that, Your Lordship, my evidence is that my learned friend already read out some portion of
I have
my
seen the-
evidences.
Yes.
And page number 38, Lordship, starting from page number 38.
One second, plaintiffs,
Plaintiff evidence,
no, plaintiffs.
starting from page number
witnesses.
38 of the
No,
paper
just
book.
I'm jotting down your point. Plaintiffs' witnesses are relevant. What page you said?
Page number 38 onwards. I'm not reading again. My learned friend already read most of the portion of my evidence.
You just have to point out the
Yes,
evidence.
Lordship, in this examination in chief, it is very clear that I have got outstanding credit in this steel fabrication in the city.
Yes, okay.
And Lordship, page number 40, page number 40. Page number 40, para 9. Actually, all these are also read out by my learned friend. And the thing is that I have substantiated all my points regarding the percentage of completion of the works, including all the related particulars, Your Lordship. And the thing which I'd like to get Your Lordship's kind attention is the cross-examination, Lordship. The cross-examination part is starting from page number 45.
Yes.
Page number 45. I'd like to read out the whole cross-examination. It's very short, Lordship, because my learned friends skip this particular cross-examination. Page number 45, Lordship.
Yes.
Number 1, it is a fact that I understand the examination in chief submitted by me. I understand the examination in chief submitted by me. Number 2, it is a fact that we do not have any written agreement between I and the defendant. It's an admitted fact, no written agreement. Number 3, it is a fact that the defendant used to pay bill by way of installment, but denied the assertion that the defendant fully paid the cost of work done by me. Number 4, it is also a fact that on 17 November 2018, I was expelled from the work. Testified again. Number 5, it is a fact that Mr. Zakir Hussain was one of the 5 head mystery, and the relation between him and I was not good. Number 6, it is a fact that we did not have a written agreement in Sajak bridge strengthening work at Rajiv Nagar also. Number 7, it is a fact that I did not complete the Sajak bridge strengthening work at Rajiv Nagar, but I claim that I had completed 90% of the work. And there's one point of re-examination, page number 47. With regard to para 5 of my cross-examination, I have clarified that Mr. Zakir Hussain was alcoholic who often caused trouble to his fellow workers and also used to misbehave to our family assets. I terminated his employment.
What
The reason-
has this got to do?
Sorry, Lordship.
What has this got to do with the instant issue? Right.
This Zakir Hussain, Lordship.
This fact that Zakir Hussain was expelled,
Lordship.
you want to say that you were also expelled on that ground?
Lordship. But prior to my expulsion, Zakir Hussain was expelled because he misbehaved against my wife. And Lordship, the reason why I'm reading out the whole cross-examination is that there's no effective cross-examination. Effective cross-examination is very crucial in civil matters, Lordship. So, totally, there's absence of effective cross-examination.
Now we cannot do anything with that.
Lordship.
Cross-examination was not proper, what can we do?
Lordship.
Then?
Yes, in the examination in chief, all the particulars are specified. So that's not even rebutted in the cross-examination. So it is deemed to be admitted somehow, Lordship. And the next thing is that, Your Lordship, my next witness, page number 48, is one of my employee who involved in both constructions. And I directly come to page number 49, para 5 and 6. Para 5, 6, 7. That during said construction of Aizolle, we work under the supervision of Mr. Lanuntara Mapuya. However, when MP Steel Fabrication was terminated from said construction of Aizolle, I also gave up the work of Aizolle, and as far as my knowledge is concerned, the total number of persons left the said construction was around 20 persons when MP Steel Fabrication left the site. Number 6, that when we left the site, we almost completed the work, and at least we finished 99.90% of the total works. Number 7, that I also worked under Mr. Lanuntara Mapuya for construction of Sajak bridge strengthening. After completion of around 90% of the work, we could not continue the work due to flood, and we left the work. And Lordship, the cross-examination is also very short. There's no effective cross-examination again. Page number 50. Number 1, it is a fact that I know the Blue Hill engineer and his team leader, Dr. Lalal Thamwana. Number 2, it is a fact that I know about the instant case and I understand the content of my examination in chief. Number 3, it is a fact that I do not know whether there was an agreement between the plaintiff Lanuntara and the defendant, the Blue Hill engineer. Totally no agreement. Actually, he's of no knowledge about the agreement. Number 4, it is a fact that the construction of Aizolle and Sajak bridge strengthening were Dr. Thamwana's work. It is a fact that I'm not deposing falsely today. Lordship.
Okay, as far as all these are concerned, I have gone through. Now you have to show me whether you are liable to get that amount from him.
Yes, Lordship. I'll come to that, Lordship. So I'll sum up this particular cross-examination. Meaning that, the Lordship, in this cross-examination, the percentage of completion, the amount of work done, completed, was in fact totally not cross-examined. The defendant, who is the PLN herein, failed to rebut all such particular statements. So, in the particular point, Lordship, I must say that my learned friends submitted before this Honorable Court that there's no proof, Your Lordship. So, proof, what does it mean? As per the Indian Evidence Act, more specifically, page number, section 3 of the Evidence Act talks about the proof. And
Evidence is nowhere defined.
sorry,
in
Lordship.
the evidence. The word evidence is nowhere defined in the Evidence Act or any other law.
Lordship.
You will get only proof.
Proved, Lordship, yes, proved.
Section 3.
Section 3, Lordship. May I come to Section 3, Lordship? Proved. Proof. I'm reading, Lordship. Section 3. The last part of section 3. A fact is said to prove, except a fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition of the supposition that it exists. Meaning that, Your Lordship, basing on the material evidence, the trial court found that there is a substantial proof, there's a proper proof of the case, Your Lordship. For that, he made a conclusion, Your Lordship. And again, Your Lordship, my learned friend strongly submitted that there is no proper form of documentary evidence in this particular case. However, Lordship, in that point, I'd like to come to section 59 of the Evidence Act itself, Your Lordship. 59. It is in chapter 4 of oral evidence. Oral evidence. 59, I'm reading, Lordship. Proof of facts by oral evidence. All facts, except the contents of documents or electronic records, may be proved by oral evidence. It's very clear. And the following section 60, oral evidence must be direct. Oral evidence must, in all cases, whatever be direct, that it is to say, if it refers to a fact which could be seen, it must be evidence of the witness who says he saw it. If it refers to a fact which could be heard, it must be evidence of a witness who says he heard it. If it refers to a fact which could be perceived by, it's not relevant here, in Lordship.
Perceived by any other sense?
Yes.
Or in any other
I'm
manner?
talking the first point, Lordship. If it is a fact which could be seen, yes. My witness is the one who actually saw the construction, in Lordship, and involved in the particular construction, in Lordship. So my witness is relevant, Lordship. And their statement is also found to be trustworthy because...
So what did they say about seeing? What did they say about seeing? They did not say to such an extent. See? No, his case is, there is no denial to the fact that you had undertaken the work.
Lordship.
Only problem is how much amount,
Yes.
whether you have got the entire amount
Yes, Lordship.
or whether you are entitled for some further amount.
Lordship.
That is the bone of contention.
Lordship.
Now here, by calculating, he said that you are entitled to get actually 98,000 something. Right?
96 lakhs.
96
96.
lakhs something. But you were given 1 crore 1 lakh.
Lordship.
So it was more than what you were actually entitled.
Lordship.
See the calculations that he had shown.
My lord,
Where
this
was
is
it?
Page 31, my lord.
31. There you are. I want your answer. 31.
I'm sorry, page 32, para F.
In his written statement.
Yes,
Page 31 in his written statement, you see.
Lordship.
That is the steals, and the exact amount which your lordships is asking is at page 32, para 5, second para.
What are your answers to that?
Lordship, I'm not agreeing with this particular pleadings, Your Lordship. Because if I'm agreeing with these particular pleadings, I should not have filed a case, Lordship. And there's a different versions.
No, you can say that his calculations are wrong.
Wrong,
To
yes.
what extent? That means you have also given 41.74 ton.
Lordship.
See the answers of the trial court.
My lords, page 80 onwards are the findings from the issue.
Page
80, my lords, 80.
18.
Starting from para 43.
No, I want to see the trial court's issues and findings.
Yes.
Yes.
I'm reading, Lordship.
Where is that?
My lords, page 80 it starts. 80.
18.
80, my lords.
80, yes.
Issue number 4.
You see issue number 2, whether you worked as a manager or a subcontractor. Here the findings were on presumption that seeing your work, it seems that you were not a manager but a subcontractor. You have already seen. Then issue number 3, whether it was prematurely terminated. There it is said that after and 99% of the work was completed, you were chucked out.
Lordship.
Right. And whether that was a premature, where is the evidence here? By your employees.
Lordship, I'll come to that point, Lordship. Regarding that premature, regarding that subcontractor, manager, interpreter, I'll also try to come to the point,
Okay,
Lordship.
you go on as you want. Okay.
Yes. Lordship, if you kindly permit me to continue my submissions in the particular cross-examination, read with the evidence, Lordship. I'll come to that again, Lordship. In that evidence act, Lordship, 5960, it says that, yes, that oral evidence is supposed to be a part of evidence. If that witness actually sees what had happened, Your Lordship, so that would found to be relevant, Your Lordship. So for that, Your Lordship, my other 2 witnesses are the one who actually undertook the construction and physically witnessed the construction. So
They
their
have seen.
statement would be trustworthy, Your Lordship. So they said that 99.9%, 90% of the work are completed, Your Lordship. But the appellant herein failed to rebut particular point, Your Lordship. So in that particular percentage, Your Lordship, there's no rebuttal. So technically, it is to be accepted, Your Lordship, in my opinion, Your Lordship. So the next thing is that, Your Lordship, for what amount that might be 96 or 101 lakh, I'll come to that, Lordship. The defendant herein, as appellant, the appellant now, submitted that, yes, the entitled amount is rupees 96 lakhs. But, Your Lordship, the evidence is totally contradictory in the particular point, Your Lordship. Why? Lordship, they said that they means he himself along with his wife stated that I was somehow like something like a mere interpreter, or manager of the work. And I was entitled to 10% of the completed amount. But, Your Lordship, in my pleadings, I stated at paragraph 4 that the total work amount, contract amount was rupees 222 lakhs. 222 lakhs. But, Your Lordship, my learned friend, the appellant, in that particular page number 33, let's say 32, stated, yes, stated that, specifically page number 31, Lordship, para 3, clause B, that the quoted rate of the work or contract rate with PWD was calculated in terms of ton, and that is rupees so and so per ton, and the whole work was estimated at rupees 141.90 ton, which is worth of rupees 1.48 crores. I may be wrong in interpreting this particular point, but in my understanding, he said that this particular 1.48 is the total work amount, Your Lordship. Means the contract amount, Your Lordship. So if it is, Your Lordship, I must be entitled only rupees 10 lakhs, Your Lordship.
10 crores.
No, Lordship. This is rupees 1 crore point 48 lakhs, Your Lordship. If I am to get 10% of the work amount, I would get only rupees 14, Your Lordship.
14 lakhs.
14 lakhs, Your Lordship. But I in good faith, stated that, repeatedly stated that, the contract amount was rupees 222 lakhs. That is also reflected in the judgment, Your Lordship. And even if it is rupees 222 lakhs, I would be entitled rupees 22.2 lakhs only, as per their version, Your Lordship. But, Your Lordship, they paid me without any objection that rupees 1 crore point something was paid to me. And now, Your Lordship, they said that I was entitled not to 10%, but 96 lakhs, Your Lordship. Maybe around 90% of the work now, Your Lordship. Even if...
So you make a difference between whether 10% of profit or this amount of work that you have done. There has to be a difference.
That's not specified by the Your Lordship during the whole process of evidence. If they are to be in such way of evidence stating that rupees 96 point lakh is entitled or only 10% is entitled, they must substantiate about that particular point, Your Lordship, in their evidence. However, Your Lordship, I'll come to that point also. They totally fail about how that 10%, how that 96 comes into play, Your Lordship. So anyway, I'd like to submit that, Your Lordship. My point is that their statement in some part stated that I was entitled only rupees 10 lakhs, no, 10% of the work amount. But they paid me rupees 1 crore above. And in some part, they said I was entitled...
10% is the profit.
Lordship. Yes, Lordship, that is the point. That particular profit, how much would be 10% of that 101? They did not substantiate at all in their evidence, Your Lordship. If they are to resort in the particular point as evidence, Your Lordship, they have to...
that part you have to explain me. Yes, Mr. Jordan. What 10% and the other amount?
My Lords, I think I have to start with this, and I will explain, my Lords, that this is a new case, the new submission at all. 10% is, as per our agreement was that, my Lords, my Lords, the works was for 10 rupees. Out of the 10 rupees that I have given you for managing, the 10% you have to, the 10% profit will come out of that 10 rupees. It's not an additional 10%. So, my Lords, this is my clarification on that point. It is not another separate relief that can be claimed. If at all, my Lords, that should have been pleaded. It is not on my burden. It is their suit. That pleading is also not there. So, my Lords, I have to conclude with that.
Lordship, in that point, in my pleadings, I admittedly stated that, yes, I received rupees 1 crore plus something, and the total work amount means the total amount is rupees 222 crores. And as I was expertise in steel fabrication, that total steel fabrication part was handed over to me by a sum of rupees, for a sum of rupees 1.5 crores, Your Lordship. That is my evidence, that is my pleadings, that's there in my very plain also. However, Your Lordship, in their written statement, in their pleadings, they stated that he is entitled only 10%. He is entitled only 96 lakhs only. But, Your Lordship...
96 lakh will not be 10%.
Yes, it is almost 90% of the total amount, Your Lordship. So that clarification...
You are confusing the matter.
Lordship.
I'm getting confused. It cannot be between 96 again, you are coming to 10%.
Lordship, yes. That is because their pleadings, more specifically page number 32, says I was entitled only rupees 96 lakh, Your Lordship.
That is by calculating your work.
Lordship, page number 32, clause F, I'm reading. I may be wrong in such interpretation, in my opinion. 96 is my entitlement. That with the PHE's money,
Which paragraph?
page number 32, clause F. F. That with the BHE's money being spent by the plaintiff, the value of all the work completed by the plaintiff was calculated to be rupees 96 lakhs.
So this is the value of all the work
Okay,
that you
Lordship.
have completed. Now you will again go to 10%. And that the defendant had already paid the plaintiff exceedingly by paying rupees so and so in installments, and out of which 10% of the amount of work completed would be his remuneration. So that is different, out of which this 10 lakhs will be your remuneration. Out of 1 crore, 1 lakh. So you will get, I think, 10 lakhs as your remuneration, apart from the value of the entire work completed. So don't mix up your 96,000 and 10%.
Lordship. But in my understanding,
If it
Your
is
Lordship,
96%, as far as, of course, I understand, I don't know, I may be
Lordship,
wrong.
Lordship, yes.
But 96,000 or 96 lakhs, then 96,000 will be your 10%, will be again your remuneration.
Correct.
Why are you mixing it up? 96% and
My lords, I just
96
want to
lakhs.
step one very important thing. If that was their case, let him show the pleadings. That is all. No pleadings, man.
Lordship, I'm still in confusion about the
You
96
do
amount,
one thing, you
Lordship.
read the entire thing properly. I'll also go through, right? Because you are mixing up the percentage of profit and the entire work done.
Lordship, the reason why I'm confusing is that in their whole evidence, they did not substantiate as to how this 10%, this 96 comes out, Your Lordship. So
No, they have said
it is
96,000. In your written statement, you
Lordship.
see, in this breakup that they have given, they have said 101.157 ton of steel they have acquired.
Lordship.
And by calculating it, it comes to 36,000 lakhs, 96 lakhs,
Lordship.
91.81.
My lords, can I just clarify that?
No,
I'm so
yes.
sorry, my lords. Your lordships is correct, my lords, in saying it. But there are two important parts of para 3. One is A, which we've given the bifurcation of the works. To total it is 141.74, 141.90 ton works of worth, which comes up to, my lords, at B, in terms of money, it comes up to about 1 crore 48 lakhs so and so.
Yes.
Out of which, my lords, the work assigned to the plaintiff is stated in C, the next subpara. Plaintiff was employed and asked by BHE to manage and complete the work only with his collected laborers and workers up to 100.157 tons. So, my lords, we said do this much, 100.157.
So this will come down.
Yes, but he did only, at subpara F, he did only 91.81 ton. That's why the 96 lakhs.
But then you paid money
Yes.
for 100.157.
No, my lords. We paid him a little lesser than that, but more than 91.8 ton.
But more than 91.
Yes.
You did work for 91.81 ton.
Yes.
Whatever it is, but then don't mix up your profit and your work done.
But that's still an issue, Lordship, because I would like to conclude in the particular part that they are contradictory in their evidence, Your Lordship. The reason is that, Your Lordship, they state that in their evidence also at page number 55, the appellant stated that I paid in excess money, Your Lordship. But if the money was paid in excess, there's no counterclaim, there's no claiming back of the
Yes,
money.
that of course have gone
Lordship.
to my, nobody will pay you extra.
Lordship,
That is
Lordship,
of
that is
course
my
not.
point, that is my point, Your
Nobody
Lordship.
will pay you extra.
So-
But then the facts are not very clear.
Lordship.
You go through it,
Yes, Lordship.
right. You make a difference, you make a written argument like he has made, making a
Lordship.
difference between profit and
Lordship,
the work
Lordship.
done. And then we will again hear it.
Yes.
But I cannot make it parted because 1 month I'm not here.
Uh-huh.
My lords.
Lordship, Lordship.
But then he has completed his argument. I was supposed to dictate. So what to do?
My lords, if your lordships find it convenient, my lords, because it is a very limited fact,
No, but he has to go through.
my lords.
He has confused himself, he has confused the court, so he has to go through. I don't want
I'll make a brief write-up also, Your Lordship, my point.
I don't want your valuable time to be wasted. That also I did not want.
Yes.
I also had heard. But then next week, try it next week.
My lords, if like tomorrow is convenient, my lords.
Tomorrow, we all judges are leaving for a program in Guwahati. So it will be difficult. Again, I'll have to carry the entire file.
My lords, because the problem is we've sought listing on several dates before your lordship.
Yes,
might
I
have seen.
understand, I understand.
And all because, my lords, he has to make disclosures of ongoing pending
Or
cases.
it can be posted after a month, so that you don't have to argue again.
My lords,
But then part third, I cannot make it beyond 1 month.
my lords, as such, I have to say, my lords, with utmost respect, this, even if he clarifies his own position insofar as that 10% and so forth, he has to just show one thing, my lords. Is there a pleading or not? Because how can he set up a relief if there is no pleading at all? Forget evidence, my lords. And if there was a pleading, was there evidence? Now, my lords, I've taken your lordships through the entire evidence. There seems to be nothing. That is my only
But then
case.
I have to be also clear about the profit part
Yes.
and his work done. And whether, what exactly should be the amount that he is entitled for.
Your lordships, if your lordships is depending on my learned friend's thing, my lords, and if it's convenient to your lordships, you can
Lordship,
take it after lunch.
my
my
learned
lords,
friend is the
we
one
may be
who
able
is-
to get some clarifications on that.
No, he
Who is
won't
more,
be-
who is more hurry, so it may be his convenient.
Because he'll have to make a note also on that.
I
It will
will
not
leave
be
it to your
so
lordship.
easy for him. Cannot be done anything. As agreed to by the parties, list this matter after 2 weeks.
My
You
lords
make a
can
note.
make it after 1 week. We'll try and get a favorable date
Okay,
together.
after 1 week, or I fix a date
Yes.
on 13th, oh no, on 21st of October,
20.
on 21st of October.
My lords, that'll be good.
You
all
make
right.
a
It's all right,
small
Lordship.
note and everything went in vain. Because I was okay, I was convinced with whatever he said. I wanted an answer from you. And
Yes,
so
Lordship.
this profit and
Lordship,
this
Lordship.
thing got confused.
My lords is
And get some judgments also how does this profit thing and the total value of the work, how it is dealt with.
Us. Yes, Lordship. I'll
My
try.
lords,
Can there be something?
My lords, I have in fact gone through several judgments. If your lordships will have to deal with the fact that, my lords, in certain when certain facts are sought to be proven, there are only certain facts which have to be proved through documentary. Unless there are totally direct, categorical statement made before in the oral testimony of witnesses, my lords. Unless, how will you prove terms of a contract, my lords? Oral agreement.
Nobody had seen it.
Yes, my
In that point,
Nobody
Lordship,
had heard
section,
it.
section 58 and section 59, 60 comes into play in that point, Lordship.
But then seeing, hearing, perceiving, there is nothing. It's an oral agreement between the parties. Okay, try it.
My lords, I
Lordship.
have one small request. I'm so sorry, my lords, if I'm asking too much. But my lords, I have seen the roster. And if I'm not correct, your lordships may be sitting here in Aizawl bench in the next week.
No,
No.
I'm there after 1 month.
Oh, I see. My lords, my lords.
Okay. On 21st, right?
21st.
Lordship.
21st, give it a try. Sorry for the inconvenience.
No, no, that's extremely good.
Chẳng bọc xìa. Cái đó là lên để máy.